Good afternoon, everyone. My name is Kristen Solis. I am one of the mentor attorneys at the Dallas Volunteer Attorney Program. I apologize that we are starting a little late today. We had some technical difficulties that we had to work through. And for those of you that are not familiar with the Dallas Volunteer Attorney Program, or DVAP, as we affectionately call it ourselves, we are a joint program with Legal Aid of Northwest Texas and the Dallas Bar Association. And our primary mission is to match low-income Dallas residents with private attorneys that will work their case from start to finish. We take a wide variety of civil cases, but one of the most common types of cases that we see come through our doors are divorces. And of those divorces, probably one of the easiest things to get started working, doing pro bono with are no kids, no property divorces. We get a ton of those, and we're always needing volunteers to take it. So if that's something that you're interested in doing, do reach out to Marcella, and she will get you in contact with Whitney Brahaney, who is our referral paralegal, and she will let you know what type of cases need homes. So today, to tell you all about divorces, is Elaine Mosier. Elaine got her Juris Doctorate from the Texas Tech University. Uh, she is actually a former managing attorney for DVAP. And after she left the DVAP program, she has been a solo practitioner specializing in family law since then. She is trained as a family law mediator. She still takes several pro bono cases and is a great resource. If you have questions along the way, please feel free to add them in the Q&A at the bottom. And if we have time at the end, Elaine will get to those questions. So without further ado, I will turn it over to Elaine.
Good afternoon, everybody. As Kristen kindly said, I'm Elaine Mosier. And one of the things that I want to talk to you about is, of course, I'm here to pitch for DVAP and ask that you take simple divorce cases. Those honestly are a good way within your own practice to learn how to do a divorce. It's because you will technically know all the steps that you need to take, whether you're doing a $50 million divorce or a no kids, no property kind of divorce. And in the packet that I think y'all got or will be getting from Maricela, there I gave y'all an example of a divorce with kids just because I want everybody to see the difference in what's required to be put into a final decree of divorce if you've got kiddos versus what it takes if you've got a straightforward no kids, no significant property kind of divorce. Now, before we get started, I want to mention that even if you have a case that is a no kids, what everybody describes as a no kids, no property, there is always something that needs to be divided and should be divided in the final decree of divorce, meaning like probably one or both of them have vehicles. You need to put that in the decree. If somebody has, I don't know, that lazy chair that they love and adore, put that in the decree that they're going to get that living room lazy chair or whatever it is. But other than that, your no kids, no property cases should all be fairly straightforward and no dramatic changes from what y'all will see in the packet of the variety of documents that are in there. So without further ado, let me get started. The first step in doing a no kids, no property divorce, as it is in any divorce, is you meet with your client and you get your necessary information. Like you make sure who lives in Texas and what county have they lived in for the last 90 days. Because in order to file a divorce in Texas, you have to have lived in Texas for at least 6 months and you have to have lived in the county where you're filing for at least 90 days. Because you find that sometimes that happens, like folks split up and then somebody immediately moves to Dallas County, or they immediately move to Collin County, or they immediately move to Tarrant County, whatever, and they haven't met that 90-day waiting period. So be sure that your clients met the 90-day waiting period, because either the divorce can be abated or some courts will just dismiss. If the other spouse comes in and says, well, she hasn't lived in Dallas County for 90 days, or he hasn't lived in Dallas County for 90 days. There are some courts that will say, oh, we'll just abate and hold until the 90-day waiting period is met. There are some courts that read the statute to mean that if you have not lived in the county for 90 days on the date of filing, period, amen, then that divorce needs to be dismissed and it needs to be refiled once the 90 days have passed. So you just want to make sure that you've got that under your belt when you're talking with your client. Also, make sure that when you are speaking with your client, that you get their full legal name and the full legal name of their spouse. You know, people go by Ricky, or they go by Bobby, or they go by, Honey Bear or whatever. But you need to have their real legal name on the document. And if it's somehow important to your client that their nickname be part of the document, you can always put, Roberta Lee Jones, also known as AKA Bobby. So you can have that in there if for some reason your client is like, but nobody knows me. Nobody will know that who Roberta is. Okay, we can AKA Bobby you, but you got to get that full legal name in there. Also, if you are representing the woman, or actually if you're representing the man, ask them if the wife wants to change her name. A husband doesn't get to change his name. We are sexist in that way in Texas, that the only name change that can be contemplated as part of the divorce is wife's name, like to return to a maiden name or return to a former name. So be sure and ask them, like, is that the name that you want to return to? Now, they cannot change their name to something crazy that they've never had before, like, I've always wanted to be Mrs. Pitt because I love Brad Pitt. So I'm going to change my name to Elaine Pitt when I get divorced. No. If Pitt's never been a name that you've had, you cannot change your name to just some random name. It has to be a legal name that you have carried previously. Also, be sure and get all of the information that you can about the responding party. By that, I mean, get their full legal name, get their social security, if the spouse has it, get their date of birth, get where they are currently living and where they are currently working, because that's going to be possibly necessary for service when you get to that stage in your case. Also, ask your client if they had any children that were born during the marriage, even if they're not their spouse's children. Because in Texas, we presume if you're married that every kid that you have is the kiddo of the person to whom you are married. And so if you have a client who comes in and says, well, yeah, I've got a 2-year-old, and you're like, okay, you've been married 5 years, so that's a child of your marriage. No. This kiddo is, we've been separated for 3 years now, and this kiddo is my, current boyfriend, fiance, whatever. Well, that's not really a simple divorce then, because there are hoops that are going to have to be jumped through in order to resolve the paternity of the child that is born during the marriage, but not a child of the marriage, meaning not a child of the two spouses who are married. So, if this is your first case, I would ask Maricela or Whitney to maybe give you a different case that doesn't have a child born during the marriage that is not a child of the two spouses. Now, of course, adoption's completely different. If your client says, "Oh yeah, we have a 3-year-old. Oh, is that your husband's child?" No, he adopted her. Okay, that counts. An adopted child is legally a child of the marriage, just like a biological child. So now again, you're not dealing with a simple divorce at that point because you've got this kiddo involved, but it's still a little easier than dealing with a child that was born during the marriage but is not of the marriage. So when you're talking to your client, the other information that you need to get, and this should be part of the packet that you've gotten, but I just kind of want to go through it to make sure that I'm hitting on all of the stuff that you need to do, is we've talked about names, we've talked about dates of birth. You need to either get a copy of your client's driver's license or write down their driver's license or state ID number. If it's a state ID number, you need to note that in your pleading, that it's a state ID, not a driver's license, because the code actually asks for driver's license and the last 3 digits of the social. So you want driver's license, social security number, full legal name for everybody. And then you also need date of marriage and the date of separation. And if they don't know the actual date of separation, sometimes when people have been separated for a while, it tends to be like, well, I left after Thanksgiving a couple of years ago. Okay, that works. If you say, okay, was it November of, 2022? Then if they say, yeah, it was November 2022, then you're fine. You can put that in the pleading as the date of separation. Now, if somebody comes to you, I find this tends to happen more in my private practice, that people separate and they're immediately ready to get divorced. That sometimes what you say is that the parties are or will be separated upon the filing of the petition. So if they're still together for some reason, and sometimes people are together for expediency, like it's cheaper for the two of us to live in the house together, even though we don't want to be married. So we're going to keep living in the house together. So date of separation may be the point at which you file the original petition for divorce. Also, be sure and ask if any real property was purchased during the marriage. And don't use the words real property. Nobody outside of the legal profession knows exactly what that means, unless they happen to be a real estate agent. Real property, say, have you bought a house or a piece of land during the course of your marriage? Because if they did, this is no longer a simple divorce, because you're going to have to either divide that house, get it sold, divide the proceeds, something's going to have to happen with that house. Also, at the initial meeting, I tend to ask clients to make me a list of what they think they want out of the house, especially if they've very recently been together. Like, make me a list with that easy chair, the TV from the living room, the bedroom suite, the pots and the pans. I've always wanted that KitchenAid mixer. It's mine, mine, mine. Be sure and ask them to write it down. They need to write it down. Don't you do it for them, because you don't want to end up with a client that's not paying attention to their decree, because I need you to understand, many, many times Clients simply assume that you've gotten everything the way that they want it. They don't read things the way as carefully as they should. So you want to make sure that you're getting them to write everything down so that you can then use that as your guidepost for dividing the property when you do the final decree of divorce. Also, you need to let them know that there are kind of two ways to deal with notifying respondent of the divorce. One is that if respondent is in agreement, like if everybody agrees, yeah, we're going to get divorced and it's time to move on, then respondent may be willing to sign a waiver of service. And a waiver of service can be as simple as I am waiving my right to be served by a licensed process server or a sheriff in the state of Texas. And it has to include their current residence address. It has to include their driver's license and some other things. But find out if, at least if at the start, if your client thinks that their spouse might sign this waiver. And if they think they might, then you need to let them know that you either need to be able to email it to their spouse once you get the original petition back, or, oh, and when I say back, let me clarify myself. No waiver can be signed under the family code in a divorce case until after the original petition has been filed, and you have to provide some evidence that the respondent was served with a file stamp copy of the original petition. It says in the waiver, like the waiver that I provided in the packet, it specifically says in there, the petitioner provided me a copy of the original petition for divorce. As petitioner's attorney, you can do that. You can do it by emailing the petitioner, or excuse me, the respondent, and saying, hey, respondent, here's the file stamped original petition for divorce that got filed yesterday, last week, whatever. And here is a waiver of service that you have to complete certain lines in there regarding address, driver's license number, other goodies like that, and that it needs to be signed in front of a notary, and then it needs to be returned to you, the attorney, so that you can file it within the case. Now, if you are going to get them to sign a waiver, I suggest that you either do everything via email, or if you do it via snail mail, send them a postpaid envelope to return it to you. It is so worth that postage stamp, because especially when I used to do a lot of pro bono divorces, I would find out from my client, well, it's done. It's just sitting at his house. And I'm like, go tell him to mail it to me, or you go pick it up and bring it to me. So I finally figured out that one of the easiest ways to get people to give it back to me is send them a postage paid envelope to send it back in, if you have to do it via snail mail. Also, just want to be clear, if the respondent is going to sign a waiver rather than needing to be served, you cannot use the unsworn declaration provision that's under 132.001 of the Civil Practice and Remedies Code. And typically you can use that unsworn declaration, the 132.001, for pleadings, but a waiver of service in a divorce specifically requires traditional notarization. Obviously, it's, the legislature is trying to avoid people forging, I'll use that word, forging a spouse's name on an unsworn declaration, because typically if you have to go to a notary, they require, some form of ID to verify who somebody is. Also, I don't know if I touched on this, but if I didn't, I'll touch on it twice now. Um, you need to let your client know that there is a minimum of a 60-day waiting period in Texas. Because let's say you get the divorce, she comes in to see you. I'm going to use she because that's typically the legal aid client. She comes in to see you. You are Johnny on the spot. You get everything prepared. You get that original petition filed the day after she comes to see you. You get that sucker back from the e-filing system. You get in touch with the respondent via email and you say, hey, here's the file stamped original petition and here's your waiver. And you need to go, fill out the driver's license number and your current address. And you need to go get this signed in front of a notary. And they are Johnny on the spot. And the day after you get it to them, they get you that waiver back. And you then send them the final decree of divorce and say, hey, wanted to let you know this is what the final decree of divorce says. And they send you back an email and say, hey, that looks good. Do you want me to sign it? And you say, sure, yeah, go ahead and sign it. And then you're like 10 days into it and you've got this whole thing wrapped up. Yay. Here's the deal. You can schedule what's called a prove up, which is where you go before the court and you ask certain questions, which are in your packet, with regard to finalizing the divorce case, but the judge cannot sign it until the 61st day, meaning that 60 days have passed since the file date. So I often advise attorneys, unless there's some agreement that you feel like is being held together with like chewing gum and shoestrings, I never do the divorce prove up in advance of when the judge can sign it, because then that puts it on me to remember when it got signed and then to have to potentially come back to the courthouse and get a copy of it from records if I don't get one of those e-served copies, and the e-served copy won't be certified. So it just makes more sense to do it after the 60 days have passed. Now, if you talk to your client and maybe you've tried to get the respondent to sign a waiver because that makes life easier, and the respondent just either never acknowledged that they received the documents, or they just send you an email that says, to hell with you, I'm not agreeing to anything. If she wants to get divorced, she better figure it out. Okay. So then you have to e-file a copy of your original petition and a letter which you ask that citation be issued, because hubby is going to have to actually get personal service. So if it's a DVAP case or a legal aid case, probably you filed it under affidavit of inability. And I sent one of those in the packet, and that's for your client to fill out. Essentially to say, I'm a client of Legal Aid of Northwest Texas, and this is my income. These are my expenses. These are how many kids that I have. Even if they're not from that marriage, the kids count with regard to affidavits of inability. And when you file your divorce, you add the affidavit of inability as a leading document. This is just for e-filing information. You file the affidavit of inability as a leading document along with the divorce, and you make a comment to the clerks. These two documents are to be filed together because the divorce is being filed under affidavit of inability. So if it's not a Legal Aid of Northwest Texas case, if it's a private case, then you need to ask that citation be issued, and you got to pay $8 for the issuance. I always advise that you call the clerks. Like if you have a process server that you use in your business, and your process server is going to go and pick up the documents. Now, most process servers don't pick up anymore. Like typically on my private cases, I just have them email to me and then I forward it to my process server and he prints out however many copies he needs of everything. But if for some reason you have a process server that wants to pick up, I would suggest that you call the Dallas County clerks and ask how much you need to pay to get second copies so that the process server has enough copies. Just that's just a tip so that your process server isn't like, well, I don't have enough copies here. Oh, okay. Now, once you've gotten past your 61st day, and assuming that you've either gotten a notarized waiver, or you've gotten good service on respondent. By that I mean your process server or a sheriff. And if you have a case from Legal Aid of Northwest Texas, the sheriff is who typically serves for legal aid. So what what you do is when you file your original petition for divorce, or actually when you ask for your citation, you notify the clerks that you want the citation to be forwarded to whichever sheriff's office serves the address where the respondent either resides or works. Now, the way that you can figure out which is the appropriate sheriff's office is you look up the zip code, and I typically then just call the sheriff's office and say, who serves 75204? And they'll tell you, oh, that's station 4 or precinct number 8 or precinct number whatever. So then when you send your comments to the clerks, when you ask for your citation, you say this needs to be forwarded to precinct 4, precinct 5, precinct whatever. And then I know I have lots of and thens in this. And then once the citation has been issued and it's been forwarded to the sheriff, give it about 10 days, call that precinct, find out if they've had success in serving it. Now, this is normally how they roll at the sheriff's office. They will get it in, they log it in whatever their system is, and then they assign it to a particular deputy or constable. And that deputy or constable is who you typically need to actually speak with. So if you find out what precinct it goes to, call that precinct. Usually they have a receptionist that answers the phone. Oh, that's deputy whomever. Usually I end up having to leave a message the first time. And then deputy whomever I find they're usually really good about calling me back. And then I can say, hey, have you tried on this particular case yet? These are the names of the people. This is the cause number. And they'll tell you, yeah, I've tried, or no, I haven't, or this is what I'm planning on trying. Once they've given it 2 or 3 shots, meaning they go to the house and either somebody answers the door and says, he didn't live here anymore, or he's not here right now. Actually, if the answer is he's not here right now, the sheriff will typically come back at a different time of day. And then if somebody answers and says, well, he's not here right now, then the sheriff will usually try a third time, again, at a slightly different time of day. And then if they still get, oh, he's not here right now, then the sheriff will hopefully call you and let you know, I've given it 3 shots. and I think we need to do an affidavit for substitute service. You get that affidavit from the sheriff, and then you do have to file a motion with the court asking the court to grant the sheriff permission to either post that citation on the door or leave it with someone who is 18 or older in the house. So if they tell you we need an affidavit of substitute service, what you do is you get the affidavit from the sheriff, you file a motion, you request that the court allow the sheriff to place the documents on the door or serve someone who appears to be 18 or older. And once you have that court order, you send the court order back to the sheriff, because the sheriff will post the court order along with the citation typically, and they'll fill the back of the citation out and return it to the court. So here's another little piece of information that y'all need. If they are served, the respondent is served, and they fail to answer by the answer date that's on the front of the citation, which is Monday next after the expiration of 20 days, and the 60 days have run, you're at your 61st day, the return of service has to be on file at least 10 days before you can enter a default judgment, meaning before you can get the divorce decree signed by the judge without the respondent ever answering or appearing in court. Because you can get a divorce in Texas without anybody ever answering, showing up, having anything to do with anything. But you have to have good service on them. By that, I mean they either have to have been personally served or they have to have signed a waiver. And if they sign a waiver, they're actually appearing. That's their modus of appearance. But if it's going to be a default where you have to get the respondent served and the respondent never answers the case, never files anything within the case, then you have to have that proof of service on file with the court for at least 10 days before you can finalize it. And if I seem like I'm really hammering on this, it's because I am. Because I don't want anybody to get embarrassed by being in court or being on Zoom with their client and the judge says, well, I don't see your service of return has been on file for 10 days, so go away. I can't finalize this. So I don't want y'all to be stuck in a situation like that. So now we've gotten him served, citations on file or waivers on file, and now you're ready to do your final decree of divorce. So your final decree of divorce is the thing that says you're divorced. Be sure that your divorce decree actually says you are divorced and these are the grounds. Because in Texas, if you don't use the words that they're divorced and that there is a ground, it is a void divorce, meaning it's invalid. And Lord, after you've done all this stuff, you do not want to end up with your client having an invalid divorce and then going off willy-nilly and remarrying and doing all kinds of stuff that then becomes a giant balled up legal mess that you might end up having to untwine. So now the sample divorce decree that I've given you is it includes the provision divorce. Just make sure. And the reason that I say this is I had never run across that before, but in my private practice, I had a client that came to see me, brought me her divorce decree, and was just sobbing and in tears because her ex-husband had said we're not divorced. You're a bigamist because you're married to two people at the same time. And she was, because whoever the attorney was who had done her initial divorce had not included the provision granting the divorce. Just, I don't know how, but somehow it just got past him. And now I will say, if you always use, like, if you use one of the document assembly programs, like the one that Westlaw has, which is ProDocs, if you use TextDocs, if you use the Texas Family Practice Manual, you're not going to have trouble with there not being a provision for granting the divorce in it. And I assume that this guy was probably using one of the forms and then somehow just managed to delete it for some reason. But for whatever, now I now add that to my things that you need to make sure that you do is you make sure that it actually grants the divorce in your final decree of divorce. So you want to make sure that everything that you want included. I know this sounds ridiculous, but reread the divorce decree to make sure that everything that you need to have in the divorce decree is in it, meaning it says the names of who's getting divorced in the body of the document. It grants the divorce. It finds that the court has jurisdiction over all the parties. That it makes a finding that there are no children born or adopted during the marriage, and then that it actually divides stuff. Even if you put something as generic as petitioner keeps all the property in her possession, respondent keeps all the property in his possession. Now, I will tell you, I don't like divorce decrees that have that kind of just general statement in it, because then later you're able to have a fight over, as I did. I did a post divorce division of property, and it was a freaking dog because these two people each claimed that they had ownership over the dog. And the language in the final decree of divorce was just, he keeps everything in his possession, she keeps everything in her possession. Well, this freaking dog wasn't with either one of them when the divorce got granted, because I don't know, they thought the divorce was stressful on the dog or something. And so the dog was staying with some friend of theirs. So the dog wasn't actually in anybody's possession when the divorce got granted. So we did like we had to do a whole case that took another 9 months to get this dog divided. And nobody wants to do that. Trust me. So you get everything done and you've got your final decree. And of course, you love, love, love it if the respondent signs off on your final decree, because then everything is copacetic. Everybody's agreeing to this thing. If not, if it's a divorce where you have to do a default because you get the respondent served and they never answer, you make sure that your proof of service has been on file for at least 10 days with the court. Then you check with the court either online or by calling the clerks and find out, does your judge like to do prove ups in person, or does she like to do them on Zoom? Because, or does she like to do them by submission? Because all of those are options now, that you can do an affidavit, and on that affidavit you can use the provision under the Civil Practice and Remedies Code to do a general verification that is not actually notarized. You do an affidavit that you submit to the court wherein your client is essentially answering the questions for a prove up, but in the form of an affidavit. And so you e-file the prove up affidavit, you e-file the final decree of divorce, you e-file what everybody colloquially calls the Austin form, but which in truth is called the information on suit affecting the family relationship for the Bureau of Vital Statistics of Texas. Oh, and there should be an Austin form in your packet. So you have to complete the Austin form. You submit that with your final decree. You submit that with the prove up affidavit if you're doing it by submission. And then typically it's the clerks or the coordinator will notify you when the final decree has been signed. Now, I know that there are a couple of courts that request that when you file final decree and prove up affidavit, that you contact the clerks and say, hey, I just filed into the queue with a final decree of divorce and affidavit for prove up, so that the clerks know to push that in to the judge's queue so the judge can review it and sign it. Because if you don't, sometimes it's just like it sits, and you never know why. You don't know why. And then you call and they're like, well, did you tell us to put in the queue? Well, no. Okay, that's why. So that's kind of how you get from point A to point B. Oh, and if you don't file your Austin form, you'll get a nasty gram from the clerks that's like, we didn't see an Austin form for this, so we're not going to send you a copy of the divorce decree back. So typically, just so you know, I try to get all that stuff filed prior to the prove up date. Even if you're proving up in person, typically all of that still needs to be e-filed. And then I always bring a copy of everything with me to court if I'm doing an in-person prove up, meaning I bring a copy of the final decree of divorce. I tell the court I filed a copy of the final decree of divorce in the queue, judge, if you want to sign it online. Also, if everything is signed online, the day that it's signed, this is why it's important to know when it gets signed. You can send your client run to the courthouse and they can get one free certified copy from the records division if they appear the date of signing, because it's the county's way of saying, well, if you were here in person, we'd give you a certified copy in person on that day. So we'll do the same thing if you prove up online. Now, if they don't run and get a copy that day, the cost of a certified copy is, I think they just bumped it up to like $1.25 a page, or it might still be $1. It's somewhere in that arena. Tell them to get a certified copy, even if it's going to cost them 20 or 30 bucks. It is worth it. It is worth it. It is worth it. There will be some reason that they need to provide someone somewhere with a certified copy of their final decree of divorce. And they can make copies of the final decree of divorce at work, or if their friend has a copy machine, or they can go to Kinko's or whatever. But tell them to hang on to that certified copy, not give that away, because usually only government agencies require an actual certified copy. Everybody else, like schools, doctors' offices, whoever, typically will just take a copy of a certified copy. So tell them to get a certified copy and then make, 4 or 5 copies of it and just keep it in a file folder or read well. And then if they go somewhere and somebody says, well, we need a copy of your final decree of divorce for that, okay, no problem. They can hand it to them. Now, the other great thing about a certified copy of the final decree of divorce is, let's say I am awarded the 2022 Subaru Outback, and the car's paid for, but it's actually in my husband's name. And he's a jerk. He won't send me the title. I can take a certified copy of my final decree of divorce to the tax office and fill out voluminous forms and get my title transferred into my name. So that's another reason to have a certified copy, because for things like vehicles, or other property that requires a filing within the county records, A certified copy is usually required, and your divorce can be used as muniment of title, meaning changing title of things by utilizing a divorce decree. So I think, let me look at my little list here and make sure I've hit through everything. Oh, let me tell you this other thing. It's about getting copies. If you want, you can request copies via email or snail mail. And you can do it by, and again, this is in your little steps to a simple divorce. So you don't have to write this down, but it's DC Records 2 at dallascounty.org. And you can tell them that you're requesting a copy of the final decree of divorce in this particular cause number. And if you've done it through legal aid, or excuse me, yeah, legal aid of Northwest Texas, you can tell them this case was filed on affidavit of inability to pay costs, and typically they will just email you a copy free. You don't have to pay for it. It will not be certified because nothing certified can go through the email. That has to go snail mail. So it looks like we're down to the nitty gritty. And I don't know that I have time to answer any of the questions, but I'll look at them. What about adult kids? You only need an adult kid information if that child would be eligible for ongoing support past the age of 18 if they're a disabled child. You do, it's weird. You're not supposed to file the Austin form. So what the clerks do, you file the Austin form and then they send it back to you because they print it and they file it to Austin. If your client can't afford a certified copy, then try and do your prove up in person so that you can get a free certified copy the day that you finalize. I don't know if I'm supposed to be typing answers to these. Apologies. Try to prove up. Get a free certified. Oh, okay. Morgan, I see you said thank you. So me answering out loud is getting the job done. Okay. So I don't see any more questions, and we are apparently 1 minute away from the end time. So thank y'all for your patience, and thank you in advance for taking some free cases through legal aid. And again, remember, this is an awesome learning experience for you. You will technically learn what you need to do for any kind of divorce.
Thank
Thank
you,
you.
Elaine. We appreciate you taking the time to present today. For attendees, I did put the MCLE course number in the chat, and I can go ahead and read that aloud to you as well. It'll also be emailed along with the packet that Elaine mentioned throughout her presentation. And that MCLE course number is 174-226-195. Again, that is 174-226-195. We thank everyone for joining today's session and for your patience with the technical difficulties. And we wish you a great rest of your afternoon. Thanks, Elaine.
Thank y'all.